Hello and welcome to Elevated Intel. This is show number 51, Rights, Reform, and People Over Profits. I'm Hector Roos. I'm joining you today solo, but that's okay. Everybody's busy. It's the summer. It's almost the summer, but there's a lot of news happening, and we could not do this to report to you what are the important issues happening today for patients, for small business owners, for veterans, for really the people that are impacted by cannabis policy. So I'm glad to be here with you. I'm Hector Roos. I'm part of the leadership team with Florida Cannabis Action Network, FLCAN.org. FLCAN.org is our website, FLCAN.org. So this is going to be an incredible episode because we have so much news to talk about. And again, this is Elevated Intel, brought to you by the Florida Cannabis Action Network. Visit us online at FLCAN.org. I'll be your host today, and this is show number 51. That's right, 51 episodes of news, education, advocacy, and elevated conversation about cannabis policy in Florida and around the country. And what a week we have to discuss. We're recording on Juneteenth. The United States Supreme Court has just handed down a major decision concerning cannabis consumers in the Second Amendment. That case involves the same federal law that became nationally known through the prosecution of Hunter Biden. We are going to explain what the Supreme Court actually decided, what it did not decide, and what the ruling could mean for Florida medical marijuana patients in the Cooper firearms case. That's Cooper versus the Attorney General of Garland. We also have a major federal rescheduling developments coming later this month. Important news from other states, new numbers showing the economic power of legal cannabis markets, and two major Florida Can events to put on your calendar. And before the show is over, we need to talk about voting, party registration deadlines, and why cannabis patients and reform advocates cannot afford to sit out the political process. This is Elevated Intel, show number 51. Let's elevate the conversation. So first, let me begin by wishing everyone a meaningful and happy Juneteenth. Juneteenth is a celebration of liberation, but it's also an invitation to examine the distance between freedom promised and freedom actually experienced. That distinction matters to the cannabis movement. A government may announce that people are free while continuing to enforce laws that restrict where they can live, what work they can perform, what medicine they can use, whether they can own property, whether they can participate in an industry, and even whether they can exercise another constitutional right. Formal freedom is important, but real freedom must also exist in practice. The history of the drug war teaches us that criminal laws are never experienced equally. The consequences extend beyond an arrest or a courtroom. A cannabis conviction can follow someone into employment applications, housing decisions, occupational licensing, education, family proceedings, and countless other areas of life. And even when legalization arrives, another question remains: who gets to participate? Do the people and communities most affected by prohibition receive an honest opportunity to build businesses and create wealth? Or does legislation simply replace criminal prohibition with a highly concentrated market controlled by a small number of corporations? That is why the theme of people over profits is so important. The cannabis movement cannot measure success only by how much product is sold or how much tax revenue is collected. We must also ask who owns the businesses, who receives the licenses, who can afford to comply with the regulations, who has access to banking, financing, property, and professional services, who remains incarcerated, who is being excluded, whose old conviction still stands in the way of a job, home, or professional license, and who gets a seat at the table when the next set of rules is written. Freedom is not supposed to mean that ordinary people are finally permitted to buy a product from a government-approved monopoly. Freedom should mean that people can participate, organize, advocate, cultivate opportunity, create businesses, protect their families, and help write the policies governing their own communities. That is one reason this week's Supreme Court decision is so important. The federal government attempted to say that a person's cannabis use, standing by itself, could justify removing an entirely separate constitutional right. The court has now said, that is the highest court of the land, has now said the government cannot make that leap automatically. That decision does not settle every question, though. We will spend plenty of time explaining its limitations, but it establishes an important principle. The government cannot simply attach every possible civil disability to cannabis use and assume no one will challenge it. On this Juneteenth, that is worth recognizing. Freedom must be more than an announcement. Freedom must be something people can actually exercise. So happy Juneteenth from all of us at the Florida Cannabis Action Network. So the Supreme Court rules on it for marijuana consumer. That's the biggest story this week. The Supreme Court's decision in the United States versus Himani on June 18th, the court unanimously ruled in favor of Ali Himani, a Texas resident who acknowledged using marijuana approximately every other day and possessing a firearm in his home. Federal prosecutors charged him under Section 922G3, the United States Code. That is a law that prohibits an unlawful user or a person addicted to a controlled substance from possessing a firearm. The Supreme Court held that prosecuting Himani merely because he used marijuana several times a week without showing that he was addicted, intoxicated while armed, or dangerous to himself or others was inconsistent with the Second Amendment. Justice Neil Gorsuch, who wrote the principal opinion, 7 justices joined it in full, while Justices Samuel Alito and Elena Kagan agreed with the judgment through a separate opinion. So the result was 9-0. This almost never happens. The lower court's dismissal of the charge against Himani stands. That is a major constitutional development, and we will break it down in detail in a few minutes. So here's the second story that we're going to talk about. The next major federal cannabis hearing is scheduled to begin on June 29th. This is it entering into the next critical phase. You may have heard that this is earlier this spring. You may have heard the Trump announcement, right? The Trump government announcement. The federal government moved certain FDA-approved cannabis products and cannabis operating through qualifying state medical run systems from Schedule 1 to Schedule 3. That was significant, but it was not federal legalization. It did not automatically resolve every conflict between federal and state law. It also did not move every adult use cannabis product into Schedule 3. The next administrative hearing is intended to consider the broader question of whether cannabis as a whole, that is the marijuana plant cannabis, sativa, as they use it, should be moved from Schedule 1 to Schedule 3. The hearing is scheduled to begin June 29th and conclude no later than July 15th, although litigation and administrative challenges could still affect the process or its eventual implementation. So when you hear someone say marijuana has been federally legalized, that is not accurate. And when you hear someone say nothing has changed, that's not accurate either. Something important has changed for the recognized medical side of the market, but the country remains in a complicated transition. Cannabis policy is still being divided into 2 categories: medical versus adult use, responsible adult use, federally registered versus state compliant, FDA approved versus non-FDA approved. Those distinctions will affect taxes, research, enforcement, banking, interstate commerce, business opportunities, and patient access. And whether regulations become complicated, large companies usually have a major advantage. They can hire legal departments, regulatory specialists, tax professionals, security consultants, and government relations teams. The small operator, the small business owner, does not always have those resources. And that is one reason anti-monopoly protection was built into the policy before a market becomes concentrated. Once a handful of companies control these licenses, supply chains, shelf space, financing, and political influence, changing that system becomes much harder. So the Florida Cannabis Action Network has submitted an application to actually to have Jodi James be presented as an expert witness in this subject matter. We've established that effectively Schedule 1 actually offers more protections for consumers and for the state-run programs, frankly, than Schedule 3. Why? Because of what I just said. The federal government or the FDA getting involved for the first time in decades in the cannabis space is a negative, not a positive. Especially where they're going to add, they admit they're going to add more regulations, more red tape, and they've not explained what they're going to be. And on the other side of that, we've also explained in our submissions that there's different types of uses that are recognized in international law, such as horticultural use, industrial use, not simply the medical use. And these are not defined in federal law or even proposed definitions presented in the rule change. So we have a lot to work on, and we're hoping that either what's going to end up happening, of course, is either we're going to get more likely than not everyone who's going to represent consumers asking for better protection than Schedule 3. They can do better than Schedule 3. In fact, the issue of like CBD products internationally with a little THC is already decontrolled completely from the international standard. So the federal government can do much better than simply Schedule 3. So that is the story of what's happening for rescheduling. The third story is that legal cannabis. The reports are out that legal cannabis has produced more than $28 billion in state tax revenue. According to a new state-by-state report by the Marijuana Policy Project, states have collected more than $28.4 billion in adult use cannabis tax revenue since regulated markets began operating. The report says states collected more than $4.57 billion during 2025 alone, the highest annual total recorded so far. Those numbers do not include the entire economic impact of legalization. They focus on state cannabis tax revenue rather than all ordinary business taxes, payroll, property transactions, jobs, or related economic activity. So those, this goes back to the conversation that happened a few years ago when the Florida legislature was proposing a ban on hemp CBD businesses that were operating under the Farm Bill exemption. The original economic report that came out said that there was 1 million customers there and almost 250,000 people employed indirectly or directly through that, and generating an enormous amount of economic activity that if that had been banned at the time would have disrupted the Florida economy. So the point is that the figures then and even today demonstrate that regulated cannabis is not a fringe market. It's a major economic sector. But again, tax revenue cannot be the only measure of success. Governments can tax a market heavily and still design it badly. A state can collect hundreds of millions of dollars while small businesses collapse. Patients pay inflated prices. Legacy participants remain excluded, and a handful of corporations gain control. The question is not simply whether cannabis creates revenue. It clearly does. The better question is whether the market creates sustainable opportunity, fair competition, patient access, and community investment. Government should not treat consumers and small businesses as nothing more than tax revenue. The purpose of legalization should be to replace the damage of prohibition with a safer, fairer, and more open system. And that's what we've been saying regarding the smart and safe campaigns, that it would be a step in the right direction. So our fourth story today goes back to what we've been talking about for weeks. Virginia, as the legislature had approved a rec market through the legislature without actually even having to go, that is an responsible adult use market, without having to go through a referendum of the people. So Virginia's governor and legislative leaders have announced a compromise intended to establish, again, this regulated adult use cannabis market, with retail sales expected to begin on July 1st of next year. Virginia legalized adult possession and limited home cultivation several years ago, but it did not immediately create a general licensed retail system. That left the state in the strange position of recognizing the legality of possession while failing to provide a completely legal marketplace. The newly announced agreement is expected to move through the state budget process and establish the framework for regulated sales. Virginia provides another lesson for Florida. Legalization is not one decision. It's a collection of decisions. So who can apply? How many licenses will exist? Can local governments block businesses? Will cultivators have a realistic path into the market? Can companies own every stage of production and distribution? Will there be home cultivation? What taxes will be imposed? Will prior cannabis convictions be expunged? Can existing medical operators dominate the adult use market before new applicants can even get a license? Those details determine whether legalization becomes an open market or a corporate protection plan. That brings us back to the central message: people over profits. Revenue matters, jobs matter, business development matters, but the freedom and opportunity of actual people must remain at the center of cannabis policy. So, coming back to the Supreme Court, cannabis, firearms, and the Hunter Biden law. Now let's dig deeper in this and elevate this discussion. United States versus Himani. You may hear this described in the news as the case involving the Hunter Biden gun law. That description is understandable, but it needs some explanation. The Supreme Court was not deciding the Hunter Biden's case. The person before the court was Ali Himani. However, the federal provision involved in Himani's case, Section 992G3, is the same unlawful user provision that gained national attention when it was used in the Hunter Biden prosecution. Hunter Biden, if you may recall, he was the son of former President Joe Biden. He was convicted in 2024 and later received a presidential pardon from his father, right? So the Himani decision does not cancel that pardon or reopen the Hunter Biden case. Or directly rule on the constitutionality of every charge that had been brought against him. But this is another potential source of confusion, especially with the pardon. The Supreme Court also released an opinion on June 18 called Hunter versus United States. That case involved a different person named Munson Hunter and concerned appeal waivers and sentencing conditions that had nothing to do with Hunter Biden or Canada's firearms policy. The marijuana case we are discussing is United States versus Himani. So what does this Section 922G3 say? In general terms, it makes it unlawful for someone who is an unlawful user or addicted to a federally controlled substance to receive or possess a firearm or ammunition connected to interstate commerce. Because cannabis has remained federally controlled, federal authorities have traditionally considered cannabis consumers, including state-authorized medical patients, to be unlawful users for this purpose of statute. In fact, if the actual ATF form that you have to complete in order to purchase a firearm includes a provision that you actually, at least the previous form, includes a provision where you would have to admit that if you were a medical patient, then you were actually also admitting that you were someone with a substance control abuse problem. And disqualified from owning a firearm or participating in the national background check system. You would be disqualified from even purchasing a firearm. Of course, that's not true, but they would make you do that. And they have since updated the ATF form into something better, but still confusing that still remains ambiguous. So, of course, this creates a conflict between federal policy and state policy. A person may be following Florida's medical marijuana law, receiving treatment on the recommendation of a qualified physician, purchasing products from a licensed medical marijuana treatment center, and complying with the state registry. Yet the federal government may still classify that person as an unlawful user, and has. Under the government's theory in Himani, regular use was enough to trigger automatic disarmament. That is, you could not own a gun, you couldn't even keep the ones you have, and you couldn't purchase new ones, of course. The government did not have to prove that Himani was intoxicated when he possessed the firearm. It did not have to prove that cannabis caused him to misuse the firearm. It did not have to show that he was addicted. It didn't even have to establish that his cannabis use impaired his ability to manage his ordinary affairs. The government's position was essentially this: he regularly used a controlled substance. He possessed a gun. That's it. The Supreme Court rejected that theory. Justice Gorsuch began the opinion by focusing on the breadth of the government's position, how expansive it was. Himani was a regular user of marijuana. The government argued that fact alone could be used to imprison him up to 15 years and potentially disarm him for life. The court then applied the Second Amendment framework, the modern Second Amendment framework, that when conduct falls within the Second Amendment's protection, the government must establish that its restriction is consistent with the nation's historic tradition of firearm regulation. The government attempted to compare modern cannabis consumers to people covered by historic laws involving so-called habitual drunkards, dangerous persons, vagrants, and individuals subject to civil commitment. I mean, that means they were insane and they couldn't even make decisions for themselves. The court found that those comparisons insufficient. Why? Because the historic laws didn't operate that way. Many of them required some process or determination before a person's liberties were taken, meaning you had to take the person to court. You had to have fact finding. You had to see what harm was this person actually causing. So many focused on people who were incapacitated, unable to manage their affairs, or demonstrated to be dangerous, right? So Section 922G3, this federal law, by contrast, automatically treated regular unlawful use of any federally controlled substance as sufficient. The statute did not necessarily require a finding of impairment, incapacity, or danger, public danger or nuisance. As Justice Gorcho explained, the law could sweep in very different forms of conduct. Someone could regularly use a small amount of cannabis as a sleep aid, or improperly take another person's prescription medication. Someone could use a controlled substance without experiencing anything approaching the historical condition of a person who had been incapable of managing his own affairs, whether because of inebriation or because of the loss of faculties. The government's analogy was simply too broad. There was also a problem with the government's attempt to classify cannabis users as categorically dangerous. The federal government's own conduct undermined that argument. Federal policy has tolerated extensive state legislation. A large majority of states recognize cannabis in some form. And in 2026 this year, the federal government itself moved certain cannabis products and state licensing medical cannabis to Schedule 3. Of course, it is difficult for the government then to argue that on one hand that cannabis had accepted medical uses and warrants a lower federal schedule in significant circumstances, and even in the promotion of a Medicaid pilot program where they're going to actually provide publicly subsidized CBD products. On the other hand, they're also arguing that regular cannabis consumer may automatically be treated as criminal or too dangerous to exercise a constitutional right. The court was not required to declare cannabis harmless. It did not do that. The government simply failed to establish that regular cannabis use standing alone made Himani categorically dangerous in the manner required to justify automatic disarmament. This is the major holding. But now we need to discuss the limits. This is where the devil's in the details. The Supreme Court repeatedly described its decision as narrow. It did not decide whether the government can prohibit a person who is presently intoxicated from possessing or using a firearm. They did not create a test. They did not decide the constitutionality of disarming a person proven to be addicted, in other words. It did not decide whether Congress could enact a more specific law addressing a particular substance shown to create an unusual firearm-related danger, like alcohol is. Like in Florida, we have the law that says that you're not allowed to carry in a bar, right? Because the link between alcohol use and bad judgments is clear. So that's why they have that law in Florida and in other states. This ruling did not decide that the government could prosecute someone after presenting individualized evidence that the person's drug use made the individual more dangerous to themselves or someone else. And did not say that cannabis consumers have a constitutional right to use firearms while impaired. So the court decided the question actually before it. Can the government automatically strip a person of Second Amendment rights because he or she uses marijuana a few times a week without proving addiction, dangerousness, firearm misuse, or actual impairment? The answer was no. And that distinction is critical. There is an enormous difference between regulating dangerous conduct and assigning permanent legal disability based on a broad status. But we've seen it. And this is where the law is starting to change. The law was against recklessly handling a firearm while intoxicated targets conduct that create an immediate danger, right? Like as I said, the carrying a firearm into a bar. So the court said that the historic record again offered that by the government did not support that much broader restriction. So what did it mean for Hunter Biden? Let's just get back to the big guy. This ruling is certainly relevant to the legal controversy surrounding Hunter Biden's gun conviction because the government used the same unlawful user provision against him. But it does not necessarily follow that the court would have treated the two cases identically. Hunter Biden's case involved allegations concerning cocaine addiction and false answers made during a firearms transaction. Basically, that he lied on his ATF form to purchase a firearm. The Himani majority expressed that decision expressly said that it was not deciding the application of the law toward addicts. It also left open cases involving individualized proof of dangerousness and substances that might create different risks. So Himani weakens the idea that the government may automatically disarm all unlawful drug users, but did not declare that every application of Section 922G3 was unconstitutional. And because Hunter Biden received a pardon, there is no existing punishment for this decision to remove. The broader significance is not that the court rescued Hunter Biden. It is that a prosecution associated with Hunter Biden brought national attention to an extremely broad federal law, and the Supreme Court has now placed constitutional limits on how that law may be used. The constitutional rule applies regardless of whether the person invoking it is politically popular. Rights that depend on popularity are not rights. A Republican should not have fewer constitutional rights because a Democrat administration dislikes them, or vice versa. A cannabis user should not lose an unrelated constitutional right simply because the government disapproves of the patient's medicine. And the law must be applied consistently. So what should cannabis consumers do right now? This portion is significant. It's important. This podcast is not about individualized legal advice. I'm not an attorney. Don't interpret any of this as permission to give inaccurate information on a federal form. Don't assume that every federal firearms restriction connected to drug use will disappear tomorrow or tonight. And the court did not erase Section 922G3 from the United States Code. It held the government could not constitutionally apply the law to Himani under the theory and factual record presented in his case. Federal agencies, dealers, prosecutors, lower courts, and Congress will not have to determine how to implement that ruling. This may be new agency instructions. There may be new litigation that comes over the ATF Form 4473. There may be additional as-applied challenges. Congress could attempt to rewrite the law more narrowly. Courts will have to decide what evidence constitutes addiction, active intoxication, individualized dangerousness, or special risk of firearm misuse. A person confronting an actual firearms purchase, prosecution, licensing decision, or government form should obtain legal advice from a qualified attorney familiar with both federal firearms law and cannabis law. The practical message for now is not everything is now legal. Instead, it's that government can no longer rely so comfortably on the assumption that cannabis use automatically erases Second Amendment rights. That is a major shift. And if you may recall, we mentioned earlier about the case of Cooper versus Garland, where members of FLCAN still have a pending lawsuit in U.S. District Court after a win at the 11th Circuit that has been stayed because of the Himani case. And now that case is going to wake up, and there will be a move to rectify their position based on the Himani case. So we will see this moving forward as well. And so the original case used to be, by the way, let's do a trip back in history, memory lane. The original case was also widely known as Freed versus Garland because Florida's former Commissioner of Agriculture, Nikki Freed, participated in the lawsuit. So the current 11th Circuit lists the Florida Commissioner of Agriculture, Vera Cooper, Nicole Hansel, and Neil Franklin against the Attorney General of the United States, the federal government, and the director of the Bureau of Alcohol, Tobacco, and Firearms and Explosives. For clarity, we just call it the Cooper case. The Cooper case challenges the application of federal firearms restrictions specifically to Florida medical marijuana patients. The plaintiffs challenge both the federal prohibition on possession and the prohibition on selling or transferring firearms to someone else believed to be an unlawful user, quote unquote. The federal district court originally dismissed the case, but in August 2025, the United States Court of Appeals for the 11th Circuit vacated the dismissal and sent the case back to the district court level. That was already a significant victory. The 11th Circuit said the government had failed at the motion to dismiss stage to show that Florida medical marijuana patients, such as Cooper and Hansel, could be treated as comparable to felons or dangerous people merely because of their medicinal cannabis use. The complaint didn't allege that these plaintiffs were addicted. It didn't allege anything about their loss of control of their behavior. They didn't even say that they participated in the illicit drug market outside of Florida's regulated medical system. And it did not certainly say that any of them were a danger to themselves or to someone else. So the court therefore concluded that they had plausibly alleged a Second Amendment violation and were entitled to continue developing their case. Importantly, the 11th Circuit did not enter a final judgment declaring that every medical marijuana patient has an unrestricted right to possess or purchase a firearm. It decided the case at the motion to dismiss stage, which is just basically they pleaded correctly. They didn't do anything really look at the facts. That means the court examined whether just if they had a legally plausible claim. That's it. The case, so the 11th Circuit did acknowledge, though, that the government could try to prove at a later stage that the particular plaintiffs were comparable to dangerous individuals, though. But the government could not simply assume dangerousness for medical use alone. Then came Himani. Himani strongly reinforces the central reasoning of the Cooper case. The Supreme Court now rejected the claim that regular marijuana use, standing alone, automatically provides a historical and constitutional basis for disarmament. Cooper and Himani and Hansel are in a more sympathetic legal situation legally especially at least one aspect. They allege that they use cannabis through Florida's state authorized medical system for medical benefits. Himani's use was still considered unlawful under both the federal framework and the circumstances described in the opinion. Yet the Supreme Court still held that his legal use without more could not justify the federal prosecution. So what will happen next in Florida? What should happen next? Well, if you want more information about the Cooper case, you can go to FLCAN.org, type in Cooper case, and you will find the historical write-ups we've and updates we've maintained in the case. So what should happen in Florida? What's going to happen? The Supreme Court's decision should substantially weaken the federal government's efforts to defend automatic disarmament based solely on medical marijuana status. The district court is bound by the Supreme Court precedent in terms of its interpretation of the Second Amendment. The 11th Circuit has already told the district court that medical use alone did not fairly establish dangerousness. And that does not necessarily mean that every remaining issue disappears. Himani directly concerned the possession of the possession prohibition in federal law. The Florida case also dealt with the transfer prohibition in the same law, in basically the same section of law and federal regulations, and the ATF Form 4473, which effectively required someone at the time to admit they were an addict in order to even to truthfully answer the form, and also disqualify themselves at the same time. So it was a catch-22. You couldn't lie. If you lied, they go after you like Hunter Biden. But if you told the truth, you'd be disqualified. So the government may argue that purchasing a firearm, transferring one, possessing one at home, and handling one while you're impaired present different questions. The government may also attempt to develop individualized evidence or propose narrow interpretations of the law. But the government's broadest argument that regular cannabis use automatically removes someone from the protection of the Second Amendment has now been rejected by the nation's highest court. That makes Himani potentially decisive on the core constitutional theory for the Cooper case. But there's a bigger issue at hand now. Florida has hundreds of thousands of people a little over 922,000 patients in the medical marijuana program. These are veterans, retirees, patients managing chronic pain, cancer patients, people living with severe medical conditions, their parents, homeowners, workers, caregivers, and community members. It is irrational to place every one of them into a single category labeled dangerous without any individualized assessment. A person, and that just means that you have to go to court on each and every case that they want to make that argument for, and do fact finding, and have a jury of your peers tell you, yeah, make the decision of make that final decision. A person, at the end of the day, the proper focus should be dangerous behavior. There's going to be these questions: is someone handling a firearm while actually impaired? Has that person threatened another individual? Is there evidence of violence, reckless behavior, addiction, or an inability to exercise ordinary self-control? Those questions concern public safety. A blanket assumption based entirely on medical patient status does not. And the issue reaches beyond firearms. Cannabis policy repeatedly forces us to confront the same question. Should the government regulate actual harmful conduct, actual violent criminals, right? Or should it punish a broad category of people based on status? That distinction affects employment testing, it affects child custody, it affects housing, probation, professional licensing, immigration, other forms of medical treatment, public benefits, and it affects the constitutional rights at issue in this case. The Himani decision does not erase every form of discrimination faced by cannabis consumers, but it sends a powerful message. The mere fact of cannabis use cannot automatically answer every other legal question. Facts matter. Conduct matters. Dangerousness must be demonstrated, not presumed. So, I hope you've been enjoying this conversation, this dialogue that I've been presenting here. We are the Florida Cannabis Action Network. This is Elevated Intel, episode 51. And before we start, we go for the day, for the week. Let's update what's happening around FLCAN with members across the state. There are two major dates to put on your calendar. Cannabis at the Capitol has been announced for March 9th. So save that date. Cannabis at the Capitol is our opportunity to take cannabis policy directly to the people who write Florida's laws. It's not enough to complain about the legislature after a bad bill passes. It's not enough to post on social media after lawmakers have already voted. And it's not enough to assume that someone will tell your story. Legislators need to hear from patients, caregivers, veterans, physicians, small business owners, family members, advocates, and ordinary voters. They need to understand how cannabis policy work in real life. They need to hear patient access stories. They need to understand the problems caused by high costs, vertical integration, limited competition, local restrictions, employment discrimination, and continued criminal penalties. They need to hear why freedom should not be limited to purchasing products from a small group of politically protected companies. Cannabis at the Capitol is about participation. It is about education, and it's about reminding elected officials that cannabis patients and advocates are constituents. So mark down March 9th and watch flcan.org for details, registration information, advocacy materials, and opportunities to participate. The next event is People Over Profits. We're back to that theme. People Over Profits, July 18th in Fort Lauderdale. Before then, we have an important, that's the important event that's coming up in South Florida. The Parabola Center for Law and Policy and the Florida Cannabis Action Network are teaming up to invite you to the 4th annual People Over Profits Anti-Monopoly Cannabis Policy Crash Course. The event will be held Saturday, July 18th, 2026 at the African American Research Library and Cultural Center, 2650 Sistrunk Boulevard, Fort Lauderdale, Florida, 33311. This crash course will bring together cannabis policy makers, regulators, activists, growers, educators, retailers, patients, attorneys, and other industry participants who share a common goal, ensuring that cannabis policy prioritizes people over profits and stands up to concentrated corporate power. The event is more than just criticizing monopolies. It's about equipping people with the knowledge and tools needed to create better policy. How do we prevent a small number of corporations from controlling an entire state or national market? How do we make licenses generally accessible to smaller businesses? How do we stop excessive application fees, capital requirements, real estate requirements, and regulatory delays that from becoming barriers that only the wealthy and politically influential can overcome? How can we structure cannabis policy so that cultivators, manufacturers, retailers, patients, and communities all have a meaningful option? How do we preserve space for local ownership? How do we protect the industry from predatory financing and forced consolidation? How do we make sure that federal legalization does not destroy thousands of state licensed and locally owned businesses? How do we build a movement for cannabis legalization rooted in justice, economic empowerment, and fair opportunity for all in a free market? That's the conversation we'll be having. The Parabola Center describes the event as both an educational opportunity and a call to action for people who reject the model of legalization that concentrates wealth and power in the hands of only a few. That the program will include presentations from experienced speakers, policy discussions, and opportunities to network with cannabis advocates and industry participants from diverse backgrounds. Come ready to learn, come ready to meet people, come ready to ask questions, and come ready to participate in shaping the future of cannabis policy. Once a monopoly becomes entrenched, breaking it apart is difficult. The time to protect competition is before the market is completely captured. Again, that is Saturday, July 18th at the African American Research Library and Cultural Center in the historic Sistrunk neighborhood of Fort Lauderdale. Visit FLCAN.org and follow the Florida Cannabis Action Network for registration and event updates. And finally, a topic very close and dear to my heart is we need to talk about voting. Florida is a closed primary state. That means voters generally must be registered with a political party to vote in that party's primary. For the 26th Florida primary, the official deadline to register to vote or change your party affiliation is Monday, July 20th. But you should do so as early as possible. And which party should you change your voter registration to? Look around you. Who has been historically the dominant party in your area? You can change your voter registration to that party, vote in that party primary to vote for the cannabis champion that we need, the policy champion that we need, and you're welcome to change back. The primary election date is Tuesday, August 18th. So although you may have heard that you must make that change before the first week of July, the official deadline is July 20th, but you have to give yourself about 2 weeks for that voter registration change to actually happen. So check your registration now. Make sure your address is correct. Make sure your name is correct on it. Make sure your party affiliation reflects the party that is dominant in your area. And make sure that you know where and how you plan to vote. Cannabis policy is political policy. The people serving in primaries, legislatures, city commissions, county commissions, Congress, and statewide office decide whether patients are protected or prosecuted. They decide whether small businesses receive opportunities or whether the market is handed to a monopoly. They decide whether prior convictions are cleared. They decide whether cannabis consumers can keep their jobs. They decide whether veterans and patients receive meaningful access. And they decide whether law enforcement resources will continue to be used against peaceful conduct or actual threats rather than actual threats to public safety. And they will decide whether government will respect the rights of cannabis consumers. Voting is not a form of political participation. That is, it's not the only thing. We also need public testimony. We need to make phone calls. We need emails. We need meetings with legislators. We need candidates who understand these issues. We need volunteers, and we need researchers. We need the people who are willing to tell their stories. And we need you. We need you to tell us if you know a candidate who's running for office in the state legislature or the federal legislature, for that matter, for Congress, who will be a cannabis champion for us. Let us know. Send them to our website. Have them fill out our questionnaire. And volunteer. We have our legislative program isn't just that one time during the session, but we even go to the earlier legislative committees before the session even starts to talk to legislative staff, to the legislators themselves, and we received an immense positive reinforcement in the last legislative session when we did that. So, in wrapping up, you should be prepared to vote, and you should be prepared to help someone else do the same. So today we celebrated Juneteenth and reflected on the meaning of real freedom. We reviewed a historic Supreme Court ruling that rejected the automatic disarmament of a marijuana consumer without proof that he was addicted, impaired, or dangerous. We explained why the ruling strongly supports Florida medical patients challenging federal firearms restrictions in the Cooper case. We covered federal rescheduling, new state developments, and more than $28 billion in adult use tax revenue. And we invited you to join FLCAN at the two important events of People Over Profits on July 18th in Fort Lauderdale, and of course, Cannabis at the Capitol, March 9th. So the future of cannabis policy will not be delivered by one court case, one election, one organization, or any one company. It will be determined by the people who show up. So stay informed, stay involved, stand up for patients, and frankly, and stay elevated. So this has been Elevated Intel, show number 51, brought to you by the Florida Cannabis Action Network. Learn more, become a member, and get involved at flcan.org. Until next time, keep learning, keep organizing, and keep elevating the conversation. Thanks so much.